Welcome to the 2021 Zoning Board of Appeals meeting of the Town of Raymond. The Zoning Board of Appeals will come to order. The board does have a quorum. I'm now going to do a roll call. I'll ask the members to state their name. Why don't we start with you, Joanne?
Joanne Stinson, 51 Haskell.
Patricia?
Patricia Beaton, 234 Raymond Hill.
David?
David Murch, Canal Road in Raymond.
Len Sorelli, Lakeside Drive in Raymond. This is a public proceeding, and unless the board specifically votes to go into executive session, you have the right to hear everything that is being said and to look at all of the exhibits that are presented. Please notify the chair if you are unable to see or hear. The board works from a published agenda, and we will be considering tonight's items in the following order. Well, as Mary said, we were going to have an interview, but that's postponed, so that will take care of new business. And we will go up in a minute into old business. In each instance, the burden is upon the applicant to demonstrate compliance with the provisions of the applicable ordinances or state law. After the board votes on the merits of each application, it will prepare written notice of decision. Because the notice of decision may substantially affect any appeals rights, and also as a matter of courtesy, the board asks that those attending the meeting with regards to a specific application not leave until the board has completed its decision. Generally speaking, appeals from adverse decisions must be filed with the Superior Court as otherwise provided by law within 45 days of the board's decision. Also, to be certain that you preserve your individual right to file any such appeal, you must be certain that the board's record evidences your appearance this evening in opposition and the basis for your opposition. All persons speaking, including representatives of the applicant and members of the public, are asked to stand at the microphone. Well, we're on Zoom tonight, so if you could just say your name and address, that would be good. State the name, address, and affiliation with the application, either for, opposed, or neutral. All persons speaking shall address all remarks or questions to the chairman. The meeting is not over until the board has formally adjourned. Any discussion not included on the meeting agenda or accepted by the board is to be held until after adjournment or concluded outside the meeting room. One second. Before we get into the public hearing, I want to remind everyone that we will not be taking any public phone calls or comments on this tonight. I'm going to read to you the findings of fact for the Levitri decision, which he was asking requests for a formal administration review of decisions of approval on conditional use application that we approved for Nicole Starlett. Okay. These are the findings of facts. The request for reconsideration was made by Mr. John F. Levitri with a mailing address of 370 Webbs Mill Road, Raymond, Maine, and a phone number of 207-655-3110. Mr. Levitri is in opposition to the Zoning Board of Appeals, ZBA, decision regarding a conditional use application for Nicole Starrett approved on December 29th, 2020. The Starrett's property in question is located at 402 Webbs Mills Road, Raymond, Maine, 04071, also identified as tax map 010 lot 027000, which is a 4-acre lot in the rural residential district. The request for reconsideration of the ZBA's decision was received on Tuesday, January 5th, 2021. This request was successfully made within 10 days of the decision made by the ZBA. A meeting was scheduled for January 26, 2021 to hear this reconsideration request. At the meeting, ZBA Chairman Len Sorelli explained to the public, members of the board, and Mr. Levitri that a quorum was unable to be established for the hearing. A minimum of 3 members who were present at the December 29th, 2020 meeting must be present at this meeting in order to have a quorum for the reconsideration request. Member Eric Welch was absent due to an illness. Member Eric Welch submitted his resignation from the ZBA on January 29th, 2021. Since the ZBA was unable to hear the reconsideration request with a minimum quorum of members from the December 29th, 2020 meeting, an attempt was made to have one of the 2 members who were either not present or not on the ZBA at the time of the conditional use approval vote on request. Nicole Starrett was contacted to see if she would consent to allow members David Murch or Patricia Beaton to vote on the reconsideration request. Mrs. Starrett did not consent to allow Mr. Murch or Ms. Beaton to vote on the reconsideration request, which was received via mail on February 10th, 2021. The conclusions of law are as follows. The ZBA is unable to hear the request for reconsideration of the decision made on December 29th, 2020, due to the inability to establish a minimum quorum at this time. The ZBA made every attempt possible to hear the request made by John F. Levitri. The decision is based on the above finding of facts and conclusion of law. The Town of Raymond Board of Appeals is unable to hear your reconsideration request made on January 5th, 2021. Is Zachary, the lawyer, here?
I am. This is Zach Brainwan, Bernstein Sure. Happy to
Hi.
answer any questions. Good evening.
Okay, I wanted to introduce you. Is it Zachary Brandwine? Is that right?
That's correct.
Close enough. From Bernstein and Sure. And I want to ask if any of the board members have questions for Zachary. And I want to really keep a handle on this. So let me call on you guys one at a time. Joanne, I know you have questions, so.
Hi, Zachary. Sure.
Good evening.
Thank you, Len. Thanks for joining us. I guess just a question of, we have exhausted all of our options as far as it was up to the Starretts to approve whether someone could step in or not, and that pretty much was the end of the rope for that.
That's correct. To proceed, without their consent and substitute new members of the ZBA for reconsideration would have been improper. It would have been sort of outside the scope of the ZBA's authority to do that. So, it's just unfortunate, but circumstances have sort of just conspired against the board being able to hear the reconsideration. You need all the original members who made the decision, or a quorum of original members who made the decision to vote on the reconsideration. And outside the board's control, and like I said, circumstances just sort of conspired against you. I think you've done absolutely everything you can to have accommodated the request here for reconsideration.
Okay, thank you.
Patricia, do you have any questions?
Not at this time, no.
How about you, David?
I just, on behalf of John Levitri, is there what further steps can he take with regards to this, if any?
I with respect to the reconsideration itself, not much. It's timed out, and I would note that the town's zoning ordinance, Article 6, which deals with your Board of Appeals, provides that the board may hear a request for reconsideration. It may grant that request and hear a reconsideration, but it is required to do so within a certain amount of time. Obviously, that's the situation that's transpired here. You tried to accommodate the request, and just because of circumstances weren't able to do so. So there's not much else he can do with respect to the reconsideration. I understand that there are a number of other steps in the permitting and approval process for the property owner here, and any abutter or interested party will have an opportunity to address any of their concerns at future stages. Those may be the same concerns that might have been at issue in the reconsideration.
Thank you.
More questions, David? Zachary, you stated this before, but I'm going to ask the question again because I want to make it clear on the record. Do you feel as though the ZBA explored every option available to them for the Levitri reconsideration request?
I do. You attempted to hold a reconsideration hearing. Circumstances outside your control conspired to prevent that within the time frame that's provided in the town's ordinance. It would have been improper to substitute new members to form a quorum for the reconsideration. And so you've done absolutely everything I think that you could have to honor that request for reconsideration.
Thank you. Board members, any other questions before we move on?
One
Joanne?
last one, just regarding what David asking about Mr. Levitri's options, Zachary, can he still appeal this to the Superior Court? I would assume the time frame held up for him to be able to do that because of...
Yeah, hypothetically, that's a possibility, although I think it's a bit of a legal reach to do so.
Okay, thank you.
Anyone else? Thank you for coming, Zachary.
My
Appreciate it.
pleasure. Yeah, happy to help. I assume you won't need me for the rest of the meeting, and I'll leave you to your business.
Thank you very much.
Thank you, everyone. Have a nice night.
Okay, now we're going to move on to the public hearing. And Mary, you can turn on the phone calls if you'd like. We only want to accept phone calls relating to this application. I don't see Tom. Is he here? Tom, you got on mute. There he goes.
I'm sorry.
Before Tom starts, I want to remind the board that the only thing that we're considering tonight is a change of use from commercial back to non-commercial, or residential, I should say. And Tom, you submitted yet another plan. We've all had a chance to look at it, and I'm sure you want to comment on it. So please go ahead.
Yeah, following the last meeting, we went ahead and revised the plan and resubmitted the following day because we wanted to, just make sure that we're, we address the board's concerns and we were get back on the agenda. But since that time, we were looking into the ordinance, and I've had some discussions with Alex on the, let me back up a little bit. I think there's been a lot of confusion on this particular site because of the past zoning board of approvals on the variances. And there was some confusion on it, even on my part, like what was necessary And at the time, when they purchased the property, they were looking to do a duplex, and they thought that that was allowed. But since then, they've withdrawn that request, and it looks as if we really don't need a variance from the Zoning Board of Appeals. So tonight almost seems like just a courtesy meeting, because we're already in the pipeline to update you on the findings and to answer any questions, and we'd be happy to hear any comments from the public as well. But a residential use is allowed in that zone, and we're not asking for a variance on any of the setbacks or the lot coverage or the lot area. So I don't, I think based on my understanding of the ordinance, we're really, the change of use is not a variance. We're just asking for a change of use.
Alex, at the last meeting, you mentioned that a survey would have to be done. I doubt if that's been done in a short time frame, but could you comment on that, Alex?
Yeah, so I mean, and that doesn't need to be done at this level. If they are going to be getting a building permit to demolish and replace a non-conforming structure, it could require a certain extent of survey work to basically establish where that structure is in relation to the property lines. And then we need to make sure that it is, the new structure is no closer than what the previous structure was. So the only way to do that is to essentially have a surveyor come out and pin the location of the replacement foundation, or give us an after the fact, certificate stating that the structure meets the setbacks of the previous structure. So that's something that'll happen down the road at the building permit stage once they get.
Okay, thank you. I want to remind the board that since this is not considered a variance appeal or an administration appeal, the hardship clause does not have to be considered. This appeal would be treated similarity to a conditional use application. And does anyone have any questions on that?
Len?
Yeah.
For full disclosure to the public, because that application was submitted and it gave the appearance that they had to fill out the variance portion with the undue hardship. Just full disclosure, both Len and I asked Alex. We did not feel that was appropriate. We were going from a non-conforming situation to a more conforming situation. We didn't feel that it looked like that it was required anyways for them to walk through the hardship criteria. So Alex graciously responded to that and helped us out with understanding the proper ordinances. So just wanted to give that explanation as to why we weren't considering the variances on that.
Thank you, Joanne. And thank you, Alex, for that. Is there anybody on the phone or that's also in favor of us approving this change of use? Is there anybody that's opposed to us?
Can't hear you, Mary.
You're muted, Mary.
There we go. Okay, I have one caller on hold. I do not know where they stand on this. All I can do is open it up and ask them.
All right,
Okay.
go ahead.
Caller at 617-823-7829. Please unmute and join us.
Hi, this is Abby Spicer, 22 Cottage Lane. Can you hear me?
Yes, we can.
Yes.
Okay, so my camp's behind the church. So yes, I'm happy to see the change in plans, and I am for the change to a single residence.
Anything else?
I was just wondering, are you going to put up a fence?
Oh, Laura, the two applicants are not with me tonight. They both are working at the restaurant, but I don't know if I have an answer for that. I think that a fence is allowed, you know, in either zone. I don't think they have really any need to put up a fence, but
Okay. And then I only have actually one other comment, and that's when you start doing your construction immediately behind the church, you know, with grass, but that's a leach field. So we just, as you're doing your construction, just be careful not to back over that because you
okay,
can
yes.
crush it.
Yeah, no, they'll remain on the property, on their property.
Okay. All right. Yeah. But I mean, if you're turning around vehicles and stuff, that was just a concern that just to be careful there.
Okay.
Thank you.
All right. Thank you. Welcome to the neighborhood.
Thank you.
Another call, Mary?
I have no other calls.
Okay, I do have one letter in opposition that that person has asked it be read into the record, so I'm going to read that to you now. This is Greg Ganya at Crescent Lake Cottages. We talked on the phone, he's talking about Mary, and you mentioned you could pass along my concerns to the Board of Appeals for the conversion of the church to a single-family home. According to Mr. Farmer, who is representing Laura Sigri, said many times at the last Zoom meeting, this is a unique situation. Please let the fence issue be part of the unique situation in your decision. As the number 3 in the 4 criteria states, the project will not alter the essential character of the locality. Their response was the project will not negatively alter the neighborhood, but will enhance the character. A privacy fence installed across the property line would negatively alter the character of the locality and would not conform to the neighborhood of 12 property owners as an alternative for a privacy fence in back of the house would offer, and a chain link fence for the rest of the land would offer protection for the dogs and not take away anything from our view. It should be in writing that there would never be anything on the property that would take away our view to the lake. Is there anybody else in
And
opposition?
I have one call trying to connect with us right now.
Okay,
As soon as the caller has connected, I'll let you know. Okay, the caller has disappeared.
should we give them a minute?
I think that would be fair.
Len, could I ask a question of Mr. Farmer? if I may?
Sure. Go ahead, Joanne.
Tom, at this point, do they have any plans for planting, vegetation, trees, anything like that put together?
No more than just the plan that we've submitted, which should be considered illustrative. They don't even really have specific architectural plans at this point. We just understand that we need to stay within the footprint that's there, no larger, no closer to the property lines. And obviously, based on this plan, it's going to be way under the square footage that's there now. And I think at this point, it's really a building application to the codes enforcement officer for building out for building permit. They do intend to live there, so I'm sure there will be landscaping, but I don't know if that's a requirement anywhere else within town for building applications for other lots in town. So I don't, I don't want to speak for them at this point.
Okay.
Hey, Joanne.
Thank you.
Is there anybody else that either opposed or in favor that wants to speak at this point? No. Okay. In order to approve, the ZBA feels as though the change of use from a commercial structure to a residential single family, one, will have no greater adverse impact on the water body, tributary stream, or wetland. Two, will have no greater adverse impact on the subject or adjacent properties and resources. That's resources. That's what we have to be aware of. So if there's no other questions, I'll make a motion to approve the change of use from commercial to residential, single family.
Len, could I ask a couple questions of Alex just before we do that?
Sure, go ahead.
Thank you. Based on what Len just read in, Alex, when they go through the permitting process, and my understanding this correctly, that because of their closeness to the lake, there will be erosion control measures that go in place. And if any trees or vegetation are removed for construction, will that have to be replaced, or do we have to state that it'll have to be replaced?
No, I don't think you need to go that far. I mean, anything within 600 feet of the water is in the shoreline zone in Raymond. So they're going to have to supply us with an erosion control plan and obviously make sure that that erosion control is in place throughout the entire length of the project. Any trees that are removed beyond 100 feet, you know, if they meet the requirements for, you know, the amount of trees currently beyond 100 feet and because you can remove a certain amount within a 10-year period, they may not need to revegetate, but they may. We would look at that. Obviously, you know, we take a look at the impervious surface ratio, the lot coverage, and all of those things go into, you know, into the typical building permit. So, I mean, I think that, you know, broad, you know, look overview is kind of what you guys are kind of, I guess, looking at here. And then once they get through this, then we'll look at kind of those fine details at the building permit stage.
Just a quick follow-up, because the fence keeps coming up. I believe you addressed this one of our last meetings, saying we really have no authority over fences. I know I looked through the ordinances upside down and I couldn't find anything except for, it wasn't in shoreland zoning, but it said we could consider the look and feel, including a fence. But I'm a little mystified by the concern over the fence situation.
Yeah, I mean, typically a fence is considered an exempt structure. So that means it's not a structure that is typically reviewed by the town when it comes to standards like setbacks, construction. So typically a fence doesn't require a permit. There's not really any special rules for it, unless it's something under site plan review. If there's a fence needed for shielding for, you know, a commercial property to a residential property, that's really the only time a fence is included on anything. I suppose you could make it part of the approval, but I mean, at that, you know, I just don't know if it's really appropriate or not with the way it's worded in the ordinance.
I have a question. How does the community ensure and go about protecting the look and feel of a neighborhood if that is a structure that isn't questioned?
I guess, what do you mean? So are you saying if they put up like a gigantic purple fence, how would we handle that?
Well, yeah, how does the community protect the look and feel of the community, which is part of the ordinances?
Yeah, that's not something that Raymond necessarily would look at, I guess, as a town. The only way we really would be in the commercial zone, because the commercial zone has design guidelines on what the commercial zone should look like as far as like landscape and architecture of the structure, stuff like that. That's really the only zone in town that we have those types of guidelines. Everywhere else in town, we don't look at, you know, the color of the house or, you know, the architecture of a fence or, you know, stuff like that.
So if the 12 houses in that area supposedly don't have fences, so nobody is blocking anybody's view, they have no recourse if the new house going up puts up a fence?
I think the only way, I mean, I'm not an attorney, but the only way I could see that ever working would be if there was something in the deed that said that there was a view easement or some type of deed restriction on preventing that view from the lake. That would probably be the only way they would have any chance of preventing that in civil court. I think. I mean, I'm not an attorney, but that's just what I would think.
Okay. I'm just playing devil's advocate because I think that's where the questions lie.
Yeah.
I think it might be if their association, like Alex said, either in their deed or they have association bylaws or something that would dictate that. But I think the town's pretty good about not telling people what they can and can't do on their personal property.
Any other questions?
Yeah, Len, I have a few if I could.
Sure, go ahead, David.
First question is the section for public comment closed now?
No, we haven't closed it.
Okay, just wondering about that. So Mr. Farmer had made a statement, which I believe to hear, that the Zoning Board of Appeals perhaps does not have any requirements in this change of use. Alex, I'm looking at the shoreline zoning provisions, and Len read from it, but it's section 12 C5, and it does state that the use of a non-conforming structure may not be changed to another use unless the Board of Appeals, after receiving written application, determines that, blah, blah, blah. So in my opinion, after reading that, the Zoning Board of Appeals does have a role in this tonight. Is that correct?
That's correct. Yeah. You guys definitely have to approve of it in order for them to change the use. Now, where it gets a little weird is in the actual appeals section, it lists the type of appeals. This doesn't really label it as what type of appeal it is. It's obviously not an administrative appeal, and it's not a conditional use. And it's also not a variance because under the variance section, it lists the type of variances, and the use isn't included in that. So either way I look at it, personally, I consider it more of a conditional use appeal, which doesn't require them to meet the variance criteria. And that's really what this comes down to is do they need to meet those hardship criteria or not? And I don't think they do because it's not a variance.
Yeah, I based on my own reading, I would agree, and I appreciate that Joanne and Len have both reached out to you with that question. My second question is for the board, and I don't think we have to answer it just this second, but again, reading from section 12 C5, it says the Board of Appeals, after receiving written application, determines that the new use will have no greater adverse impact on the water body, tributary stream, or wetland, or the subject or adjacent properties and resources that than the existing use. I would just ask that we as a board agree to that before making any motion. And then finally, again, continuing on this reading, it says, in determining that no greater impact will occur, the Board of Appeals shall require written documentation from the applicant regarding the probable effects on public health and erosion and sedimentation, water quality, fish and wildlife habitat, vegetative cover, visual and actual points of public access to waters, natural beauty, floodplain management, archaeological and historical resources, and commercial fishing and maritime activities, and other functionally water-dependent uses. To me, the key part of this is the Board of Appeals shall require written documentation from the applicant. Is that something we need to include if we choose to approve this conditional use? Is that something that we need to include as part of that conditional use? Or is that something that would just simply naturally flow out of a building permit? Alex, do you have any insight onto that part?
Yeah, I mean, I think that would be something that you guys need to at least touch on. I think some of that they probably have given us in writing, but there's a few of those that they probably haven't. It might be something that we could get that from him now during the meeting. And that would probably be enough in my eyes, at least that you guys have checked on each one of those to make sure that they can be met. You know, I think we've had them come to a few meetings at this point. I think we probably would want to try to avoid making them come back just to meet those. But if that's what you guys decide, then you know, that's what you guys decide.
Right, and I don't disagree with you in terms of having multiple meetings, and I don't want to belabor this and make it longer, but you know, given the requirements of us, you know, I think it's important to make sure we're doing due diligence to meet the expectations of us. So I put that out there, you know, for the board to obviously talk through as well. But that's it for my questions, comments.
Thanks, David. Anybody
Well-
want to comment on David's comments?
Yes, because that raises a question in my own head. Is there an existing septic on the property right now?
Not that I know of, not that we know of.
I believe there is not. I can pull the file if you wish.
Because wouldn't that affect everything that David just mentioned in some way?
Well, we've submitted an application to Alex, and it was done by a professional soil scientist, meeting the guidelines of the state.
The EPA,
Excuse me?
EPA and the water quality and the Raymond waterways?
I'm not sure about those specific agencies, but it, as far as I know, it still needs to be approved through the town and the state.
Okay. All right. Thank you.
Anyone else?
Len, just to follow up, David, fantastic questions, and you're absolutely right. And what I'm wondering is if maybe we can close the public comment portion and then walk through those various concerns under number 5, and maybe as a board, I think there's some in there that David mentioned that may not be applicable to this situation. So maybe we can narrow it down to the ones that we have concern about, and we can have Tom speak to what he sees as potential problems or what they might do to avoid any problem, just to walk through those.
If I may, I've pulled the file. There is no record of an existing septic system on the property. An application was submitted in 2017, but nothing was ever done with it.
Thank you.
All right, board members, what do you want to do? David, do you want to make a motion on this, or?
I don't know if a motion's applicable at this point. If anything, I would just like to do perhaps as Joanne suggested and talk through these things as a board to see what we believe is being met or possibly needs more discussion.
Okay, let's do that then. What's the first point? I don't have it in front of me.
Well, I guess, and two, to speaking to Joanne's, do we want to specifically state that public comment is closed?
Public comments are now closed officially.
Excellent. I'm looking at it, Len, again, shoreline zoning provision, section 12(4), C5, sorry. So the zoning board needs to determine that the new use, residential, would have no greater adverse impact on the water body, tributary stream or wetlands, or on the subject or adjacent properties and resources than the existing use. So no greater adverse impact on the water body, which probably is what is applicable here, or on the subject property or adjacent properties and resources than the current existing use.
I don't believe the new structure would be any different than the old church. as far as those points are concerned.
Is it a question, David, of during construction more so than after?
I think it's more so, I just want to make sure that we are in agreement because it's the ordinance specifically states that, you know, we need to determine that there's no use. Well, I just want to feel comfortable that we as a board agree that there won't have a greater adverse effect. I agree. I don't see anything, although I do appreciate the comment on the septic. But, you know, I don't see that putting in an approved septic was going to cause any adverse effects. So, you know, from my perspective, I would agree that this new use would have no greater adverse effect. You know, I would just, from the rest of you as a board, want to hear whether you would agree with that or
I can speak to, that's partly why I was asking the question about erosion control measures during construction, is to protect the water. But I would agree with David. I don't see any issues, and also with Len regarding the water body, tributary stream or wetlands, any different than with the church being there once the construction is over. So as long as they're following the proper erosion control measures to protect the lake. And I don't know if, you know, Patricia, your thoughts, and even Tom, if you have any further thoughts about any comments on that, because normally if we require written statements from you about that, if you just want to make a statement for the record after Patricia maybe makes a comment.
Well, I think a lot of this is covered during the building permit process, and they have to adhere to that. And then, so I'm comfortable with that, but thank you.
Yeah, I could add a little bit to that. I know as far as the state's definition of those no adverse impacts within the shoreline zone over what exists, they're really concerned with making sure that it's not closer to the water body and it's not larger square footage of impervious surface, meaning the roof and driveway and walkways. So we're well under what currently exists. It'll be more conforming and better for the location. And as far as erosion control, luckily the site is literally almost, you know, dead flat. Typically in shoreline applications, you've got a steep slope to the water, almost in every application. But here we've got a road in between us and the lake. We don't have frontage on the lake. There's no drainage structures that will be draining from this property into pipes and piping into the lake. So I think the water quality is certainly not going to get worse. There will be erosion controls just in case, but I honestly can't see any impacts because of the road in between us and the lake.
Are there any other points you want to bring up, David?
Just the one, and it's because I'm a stickler for what the ordinances say. It doesn't sound like, you know, I believe we can make a decision, yes or no, that, you know, for the change of use. But the ordinance clearly states that the Board of Appeals, in determining that no greater adverse impact will occur, which I believe we've all agreed to, the Board of Appeals shall require written documentation from the applicant. So, I mean, I don't believe, from my perspective, I don't need, from what I've heard tonight, I'm comfortable with approving this, but I would need some guarantee that we get this, you know, this written document, simply because that's what our ordinances require. So,
just a quick comment, and I'm not sure, David, but Mary, maybe this is to you, since the record of the meeting, the official record is the video.
Yes.
is that considered the same as a written statement in this case? Do you know? Or maybe Alex knows, I'm not.
If it is the official record, such as in many cases written minutes were, as far as that applies to any statements by the applicants, I'm not a lawyer, so I really would hesitate to say definitively.
Yeah, that's a tough one. I would agree too. I mean, the meeting video is the record as far as the minutes go. And then you have a written decision, which is the written decision. I mean, in this case, I think it could go either way. I don't necessarily disagree with David at all. I mean, I think that, you know, you guys could, I mean, it's reasonable to think you guys could approve this and then just essentially condition it on him submitting findings for each one of those written findings that we can attach with the application that they had submitted. I think if you do that, though, you just want to make sure that what he would say for each one of those is okay in this meeting now, and then just get him to send it over in writing. I mean, an email would be fine with each one of those, and then we can, you know, essentially put that in the record for the application.
Then Len, if I may, then just to wrap it up, then if we want Tom to speak to each of these, like David said, there was a second point about no greater adverse impact on the subject or adjacent properties and resources. Now, I'm under the impression that people are going to say that a fence has an adverse impact to the area. I personally disagree. I think we don't have authority over fences. It's still not clear to me what kind of fence that it is suppositioned is going to be on this property that's going to block everyone's views when they set up higher than this property, and it's going to be a two-story single-family home. So I'll just make a comment, and you know, like David said, if the other board members just want to say their thoughts on it, that again, I feel that they should have the same rights on this property as everyone else does on their own properties as to what they do with it, as long as it's in keeping with the ordinances and they meet all the permitting that they're supposed to do. So I think a nice single family home will add to the area. It'll make it look much nicer. It'll make it much more appealing, residential. It is a residential zone. And I don't see that there's going to be any harm to any resources. So that's just my thought, that I feel like Tom's fine on the second points as well.
I agree with you.
To add a little bit to the fence conversation. They have no plans for fence. It could, they do have dogs. It could be an invisible fence. But I just want to say, like, as far as no adverse impacts over what currently exists, this is a 93-foot long building that's over 20 feet high. It's 11 feet from one property line and it's 15 feet from the other property line. It pretty much fills the whole site. And you can see, you know, even though this may not be the exact footprint that they're looking for, they're actually talking about a smaller footprint than what we've submitted tonight. But that's, you know, 53 feet. So it's you know, it's half the distance across the site. I think the views to the lake, if that's the concern with the fence, are going to, you know, that certainly won't be more adverse, even with a fence.
I'd just like to say it on the sidewalk. It was just a passing comment. I don't know if you were there, Joanne, when I was talking to the applicants. It was a passing comment that they may need a fence for their dog. And somehow that's blown up into a big fence thing. But like Tom just said, I don't even know if they really want to put up a fence.
it's a busy road, no question. So, but I know that the dogs they have are small dogs. I don't think they're going to put up a huge, solid fence. They want to see the lake as well. And they don't want to feel like they're enclosed.
Joanne, help me out here. What should we do? Should we make a motion with attachments or?
Yeah, I think, Len, you had the motion. It's on the table, and if we just
Right.
add a condition to the motion, just a quick, I just wanted to address all of this as well, I think, to wrap it up. Maybe it's important to note that DEP did respond to their thoughts about this. And I think it was Jeffrey Kalinich from the Maine Department of Environmental Protection said, since the parcel is already zoned residential on Raymond Shoreland zoning map, the department is not opposed to the appeal request. But anyways, I just want to toss that out there that has cleared that hurdle. But yeah, I would amend Len's motion to add the condition that Tom put in writing the comments that he made this evening, that the structure changing to residential will have no greater adverse impact on the water body, tributary stream, or wetland, and will have no greater adverse impact on the subject or adjacent properties and resources. And submit that with the file for approval.
Everyone happy with that? David?
Yes and no. It kind of, Joanne, it comes into the second part of the ordinance where it says Board of Appeals shall require written documentation from the applicant regarding probable effects on public health, erosion, sedimentation, water quality, fish and wildlife habitat, vegetative cover, visual and actual points of public access to waters, natural beauty, floodplain management, archaeological and historical resources, and commercial fishing and maritime activities and other functionally water-dependent uses. So I think Tom has already spoken to the first part that we just discussed, and we all agree as a board that, that's not going to block this. I think it's, so that we agree on is those other pieces that we got to get the written documentation from. Again, I don't want to be like Debbie Downer here, but I just want to make sure we're meeting, specifically the requirements of us, and it says we shall require this. So I feel like we got to
How would the applicant respond to the public health? I don't know what they do for that. Anyone?
I don't know.
Well, I mean, some of the things that you would consider in public health are wastewater. You could even say traffic, arguably could be a public health issue. But typically when you're thinking public health, it's mostly sanitation related. So, and I think David's totally right. It would be good to get something from Tom that basically says, our application will have the following effect on health and public safety, and then whatever that ends up being, and then erosion and sedimentation, whatever the effect would be, water quality, whatever the effect would be. And some of them might be no effect, but we would still just want to get that from him.
Great.
Do we need to discuss those as a board, or we can ask him just to respond to them? Does anyone have comments on all the other, on the public health, erosion and sedimentation, water quality, fish and wildlife habitat, vegetative cover, visual and actual points of public access to the waters, natural beauty, floodplain management, archaeological, historic, all of that?
I guess I don't want to keep bringing up the fence, but the fence, visual and actual points of public access. So the visual access. But again, I agree that it's their property. If they decide they want to put a fence up, it's not for us to say yes or no, unless they're putting up a 80-foot tall fence, which I don't believe is the case. So
And I'm assuming all of these, when they say no greater adverse impact, it's impact is that structured around the ordinances of Raymond? Because to David's point, anyone could say, well, a fence visually impacts me, but we don't have authority over that. So I don't see the need to address it. So I guess I'm trying to help with David's thought around clarifying what it is and Len's thought about what does one write about these things.
Well, could he write, for example, access to waters doesn't apply, something like that, to make it simpler for him?
It seems, no, go ahead.
I just wanted to say, I think we need to keep it in the context of the Shoreland Overlay District. We're talking about the change of use approval through the ZBA because it's within 250 feet of the shore. So those issues are related to shoreland issues and not necessarily just residential or commercial. I don't know if that helps, but.
So are we basically requesting that they write up a plan for, I mean, we have a drawing of what they're going to do, but more of an extensive plan that does talk about, whether they're going to meet what this plan looks like, how will it impact the parking for the boat launch, for example. I'm still not sure. Water quality, erosion and sedimentation, those will all be addressed, I believe, in the permitting phases and, permitting for construction and permitting for septic systems. They have to meet all of the DEP guidelines for any of that stuff. Natural beauty, again, that would be landscaping possibly. And I don't know that floodplain management is relevant. Archaeological and historic resources, I'm not sure that's relevant.
No.
Commercial fishing and maritime activities, I don't believe that's relevant. So. Go ahead, David, sorry.
I was just going to say to Len's point, some of those things, like when you say archaeological and historical resources, the document just simply says, what are the probable effects? Probable effects would be none. It could be simple as that.
Okay.
So do you want to add these conditions to the motion?
I can, if you'd like, I'll add to, I think Len's motion was to approve the conditional use or the change of use from commercial to residential. And the condition for the board approving this is for Tom to write up and document how this project will have no greater adverse impact, or whether it would have any greater adverse impact on public health, erosion and sedimentation, water quality, fish and wildlife habitat, vegetative cover, visual and actual points of public access to waters, natural beauty, floodplain management, archaeological and historic resources, and commercial fishing and maritime activities and other functionally water dependent uses. And I would assume he submits that to go in his file, Alex, and would you oversee that?
Yeah, we would put that in the file, and I think maybe you add something if there are the condition is only if they have none that are a greater impact. If you catch what I'm saying, so that if there was one that was going to which we know there probably won't be here, but if there was one that was going to be more of an impact than the previous use, then they'd have to come back to you guys.
And who decides if it's greater impact? We do.
Al, you can leave that up to me, I guess, if you want. If you want, that's up to you.
Okay.
Okay, let me amend that motion again then. Let's try it.
Go ahead.
Can I continue on from where I left off?
Yeah.
Yes.
That Tom will submit this document in writing to Alex. And if Alex finds there are greater adverse impacts to any of those categories, then we request Tom comes back to the zoning board to revisit those categories to see what the impacts are. I'm
That's
not sure
fine.
I got that.
You did.
So if that's good, someone can second that. If
You got
not,
that,
feel
Mary?
free.
I would second it. I can
I'm
second.
not going to repeat it.
Do we have a second?
Yes,
Yeah.
I'll second that.
All right. Let's vote on whether or not to approve the change of use from commercial structure to a residential single family. All those in favor, please raise your hand. That's everybody. So the motion passes.
Okay, thank you.
Julian, thank you for your help on
You're
that.
welcome.
Oh, no, you're welcome. David, thank you. That was very good.
Yep.
Okay,
All right.
what do you get left here? Code
Thank you, Tom.
Thank you. Have a
Yes,
good night.
thanks, Tom.
Thanks, Tom. Now we have code enforcement officer communications. If you have any, Alex.
Yeah, I don't really have any, but one of the things that we're going to work on eventually is cleaning up the application process a little bit for the ZBA, because, for example, we really should have a separate application for this change of use of a non-conforming structure in the shoreline zone, even though that's incredibly specific. It was so confusing for them to apply, not knowing, is it a variance? Because, he spent a lot of time putting together that application. All the time he could have put into that variance hardship criteria, he could have put into answering those specific questions. So, this change of use application for you guys could basically say you need to, in writing, answer all of these or explain, your reasoning for all of these. So that's kind of one of the projects that, I hope to put on the to-do list here pretty quick. And because you guys do have a few different applications, variance application, depending on if it's shoreline or not. And then you have the setback reduction, administrative appeal, and this change of use, and then conditional use. So there's a lot of different things. And I know Mary probably deals with it more than I do, but people, when they're applying, honestly have no clue really what they're looking at. So we can make it easier.
Joanne has questioned this ever since I've been on the board.
So Joanne, we're gonna fix it.
It's been all over there.
Thank you, Alex.
We do have an application for the March meeting, and the fellow applying called and asked if he could come in and have me help him with it, because he hadn't a clue.
Yeah.
And it was much more simple than he thought from looking at it. But yeah, there's a lot of things that need to be fixed.
Yeah, so that gets added to the list, but I think as far as code enforcement stuff goes, that's probably it. Like Mary said, we do have a variance coming in for next month, which should be an interesting one. And then Joanne, is that your last meeting next month?
It is.
So I think we can have a party, a Zoom party for you on that. But no, that's all I have.
Thank you, Alex. Before we adjourn, I just wanted to say thank you to Eric Welch for the time he spent on the board and his contributions to it. And I'm sure the board agrees with me that we all hope his health gets better.
Yeah, thank you, Lynn.
You're welcome. So the Raymond Zoning Board of Appeals meeting of 2/23/2021 is now adjourned and closed. Thank you.
Thanks, you guys.
Thank you. Good night.
Thanks.
Bye.